Hi, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with disclosures. Now, if you watched last week's contract tip, you saw an in-depth video tutorial on the seller's property disclosure as far as does the seller have to fill one out, what's the differences between the GAR property disclosure form and the RE form, and what is your responsibility as a licensed real estate agent with regards to what you do or do not have to disclose, or what you do have to disclose regarding the actual property itself. So again, if a seller, well, just watch last week's video for more information on that. But continuing on that theme, as a real estate agent, there are lots and lots of disclosures that you and your clients have to deal with and interact with. So I got a lot of questions on last week's video and wanted to go ahead and extend and further the discussion on disclosures and what clients need to disclose and what you as an agent need to disclose, and are there differences between working with a client and working with a customer. So I've put together a whole list of different disclosures that you are going to interact with on a regular basis throughout your real estate career, and actually throughout every contract. Now, this is by no means a complete list, but some things that you definitely need to pay attention to. Number one is the seller's property disclosure. And just as a bit of a follow-up to last week, you must disclose any known adverse or latent conditions must be disclosed, even within a mile of the property. But there's not a specific form under which the seller needs to disclose that. So if the seller chooses to not complete an entire property disclosure form, number one, as you know from last week, you have to amend your listing agreement. But number two, they don't have to use the seller's property disclosure form, but they do have to disclose it on some sort of documentation. And Beretta requires that a broker engaged by a seller shall timely disclose the following to all parties with whom the broker is working: all adverse material facts pertaining to the physical condition of the property and improvements located on such property, including but not limited to material defects in the property, environmental contamination, and facts required by statute or regulation to be disclosed, which are actually known by the broker, which could not be discovered by a reasonably diligent inspection of the property by the buyer. And number two, all material facts pertaining to the existing adverse physical conditions in the immediate neighborhood within 1 mile of the property, which are actually known to the broker and which could not be discovered by the buyer upon a diligent inspection of the neighborhood or through a review of recently available government documents. So again, there was a more thorough discussion of the seller's property disclosure form on last week's video. Second thing you guys have to disclose, lead-based paint. We know if a property was built prior to, correct, 1978, you absolutely must use the EPA lead-based paint disclosure. If you are walking through the property or listing a property and any part of the property looks like it could have been in there prior to 1978, for example, an antique mantelpiece on a modern fireplace or reclaimed barn wood out on the veranda, anything that looks like it's prior to 1978, I absolutely suggest you protect yourself and point of practice, use a lead-based paint disclosure form regardless. So I would definitely use that. Agency representation. You must disclose per Beretta. You must make a clear disclosure on the agency representation of what types of agency the firm provides. Dual agency disclosure. You guys know that all parties must voluntarily consent in writing to a dual agency, and that is contained in both the GAR and the RE forms contracts. Commissions and fees. You guys have to disclose that. Commissions is required regarding who is being paid and by whom. Now, the amount can be stipulated on a separate commission instruction form. Referrals, or the separate listing forms and buyer brokerage forms. Referrals, we've talked about this in the classes. You guys, if you have not taken a contracts class, make sure you get in one and make sure you take that license law class. But referrals, you have to disclose before the referral is made, stating that the referral agent will receive a fee for the referral. and it is considered per license law an unfair trade violation if you don't. So basically you're going to send a broker-to-broker referral form to make sure that you get paid, but the person being referred has to acknowledge and consent to the referral as well in writing. Rebates to principals must be disclosed in writing, and also at the very least must be on the closing disclosure. Rebates cannot be given back after closing because they have to be disclosed on the closing disclosure. Material relationships, you guys know this, you have to disclose a material relationship. Now, material relationship is not only a familial relationship, but a business relationship or a past business relationship. And we've had videos on this too about past clients. If you have a regular ongoing past client, that potentially could be construed as a material relationship with that client. Better disclose it. Environmental conditions. Any known environmental conditions must be disclosed, such as underground storage tanks or hazardous chemicals stored on the property. Radon. There's not a state required form in Georgia for that, but if there is the presence of radon or suspicion of radon, if there's contamination, absolutely must be disclosed. Disclosure by a broker working with customers. So for example, if you are a transaction broker in the sense of you are performing ministerial acts for the public, in other words, you are working with the seller or the buyer as a customer rather than a client, then you must disclose all known adverse facts or latent physical conditions within a mile of the property, as well as how the brokerage is getting paid. History of the property. So this is really having to do more with a stigmatized property. If you as a licensee are asked point blank directly about the history of the property or certain events that occurred within the house, for example, violent crime, known illness, you must disclose it. So for a stigmatized property, you are not allowed to disclose it in general, but if you are point blank asked, you must tell the truth. The only exception to this is if somebody died of AIDS within the house. Even if you are point blank asked about that, you are not allowed to disclose that. And financial ability to pay the seller on a financed loan. So in a case where the seller is financing the sale, the buyer's agent is actually required to disclose if you actually know if the buyer is unable to repay the loan or if the buyer does not intend to live on the property. So per Beretta, it states a broker engaged by a buyer shall timely disclose to a prospective seller with whom the broker is working as a customer and who is selling property which will be financed either by a loan assumption or by the sellers providing a part or all of the financing, all material adverse facts actually known by the broker concerning the buyer's financial ability to perform the terms of the sale. And in the case of a residential transaction, the buyer's intent to occupy the property as a principal residence. So you guys, lots and lots of disclosures. Make sure you are covering yourself by disclosing everything that you are required by law to disclose. This by no means is a complete list. Additionally, please look in both sets of contracts, the GAR contract forms as well as the RE contract forms. There are many consumer brochures that I highly encourage you use in all situations, in every situation where it is applicable to your clients and customers. Make sure you get those consumer brochures in their hands. They will protect you. In addition, Maximum One provides what we call a service recommendations list, and you can find this on the extranet and in the reference section of Paperless Pipeline. And basically what this is you as the licensed agent and the professional highly recommend that the buyer, for example, do the following. For example, get a survey of a property, have an independent home inspection of the property, have a termite inspection done of the property, have the house rekeyed after they move in. There's a whole list of items that you as the professional recommend to the client to do. And then the client marks off if they are choosing to do that or not. You get them to sign it, you get that in writing, so that if they get let's just say, amnesia after the sale and say that you never, as the agent, you never even mentioned anything about getting a survey or a termite clearance letter or something like that, you will have this documentation to remind them of the fact that, yes, as the professional, you did absolutely encourage them to have a home survey of their property before they purchased the property, and they declined to have one. So take a look at that. Again, that form is called Service Recommendations. It is on the extranet and in the reference section of Paperless Pipeline. So remember to disclose, and thank you so much for watching. I'm Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.